सर प्रणाम सर, पंडित सर प्रणाम।
जी नमस्ते
सर नमस्ते सर। सर thank you for joining and sir congratulations for your new assignment sir.
जी thank you. I'm trying to change this.
Sir, in YouTube live streaming there are 5,000 people they are watching sir. We have got a very excellent response.
Professor Pandit, namaskar.
नमस्ते।
Sir, Ahuja sir, I think we have Tejas Karia sir is in this session.
We have Tejas Karia, but he has not joined.
Yeah?
He has not joined so far.
He is not?
He has not joined.
Okay sir. He will join soon sir.
Sir, I'm joining now. They just
Prathiba ma'am will join soon. She will join by 9:58.
Okay. 9:59. Tejas sir, good morning.
Very good morning. How are you?
Namaskar sir.
Namaskar.
तेजस साहब आपने अभी तक डेट नहीं दिया, हम बच्चे पूछते रहते हैं।
मैं अभी दे देता हूँ आपको। मैंने एक्चुअली में कल ही शाम को मैं याद कर रहा था। जस्ट गिव मी अ सेकंड।
तो सर आप सर को बुला रहे हैं क्या सर?
हाँ सर आना ही नहीं चाहते, क्या करें, मैंने तो ओपन इन्विटेशन दिया हुआ है।
ऐसा नहीं है सर, बिलीव मी।
कारिया सर, आहूजा साहब वो लिमिटेड लोग को बुला रहे हैं वहाँ।
हाँ 7th में कैसा रहेगा सर? 7th में
मैं देख करके आपको रिस्पॉन्ड कर दूंगा आज।
ठीक है, मैं मैसेज ईमेल भी कर दूंगा मैं आपको आज।
Madam is also joined.
Good morning.
Ma'am, namaskar ma'am. Good morning ma'am.
Ma'am, namaskar.
Nice to see you, Professor Ahuja, Professor Mishra.
Thank you ma'am. Thank you ma'am.
Mr. Karia.
Good morning ma'am.
Unnat bhai, good morning.
नमस्ते मैम। Good morning.
Happy Ram Navami to all of you.
Thank you ma'am. Same to you.
Thank you. Happy Ram.
Anji, क्या करना है मिस्टर मिश्रा?
मैम बस अब स्टार्ट करने वाले हैं, बस 2 मिनट मैम बचे हुए हैं।
ठीक है, बढ़िया. So tell me, has anyone given you statistics about mediation in Delhi in commercial and IPR disputes?
So that we are expecting from you, ma'am.
Okay, I wanted to know because this is the second day of the conference, so I wasn't sure. So I thought I'll ask you all.
Ma'am, from Delhi High Court only you are representing.
Okay.
I think no one is from Delhi High Court.
Right, no problem.
Ma'am, get the Copyright Act amended, you know, all these references to IPAB and the Copyright Board, they should go. And, you know, whatever necessary amendments are required to be made in the light of this Commercial Act, Commercial Disputes Act, that should be incorporated.
वो तो हो गया है already.
नहीं, ऑलरेडी ये जो कॉपीराइट एक्ट में अमेंडमेंट कहाँ हुआ है?
हुआ है. In the Tribunal Reforms Act, various provisions of the Copyright Act have been amended.
अभी जो कॉपीराइट एक्ट का बेयर एक्ट आप खरीदते हैं ना, जब it is having the same references of,
reflect नहीं कर रहे हैं because they don't know, I think.
उसमें like उसमें जो references हैं of copyright code and the IPAB,
it has been changed. It has been changed already.
अच्छा, वो बेयर एक्ट में फिर चेंज नहीं कर रहे हैं, वो पता नहीं.
हाँ जी, हाँ जी.
एक्ट में तो आ गया था, उसमें तो क्लियर है. अगर आप उन दोनों को मिला के पढ़ेंगे देन एवरीथिंग इज क्लियर. बट कॉपीराइट एक्ट इंडिपेंडेंटली जब हम देखते हैं ना, उसमें अमेंडमेंट की जरूरत है. वो रेफरेंसेस वहां से हटाने हैं.
The बेयर एक्ट publishers have to do it ना. उन्नत भाई,
इसके लिए उन्नत सर से सर आप बात करिए सर. आप सर राइट पर्सन से आप बात करिए ना. उन्नत पंडित सर रेकमेंड करवाएंगे सर.
has Unnat भाई taken over? आपने टेक ओवर कर लिया?
Yes, I have joined.
तो फिर आप ये टाइटल चेंज कर लो अपना.
हाँ, वो शायद एडिट नहीं हो रहा है, एडमिन से एक्सेस नहीं है मुझे.
But ma'am, he will always be their professor, ma'am. Once a professor, always be professor, ma'am.
Maybe let me
Just
join
like
again.
once a justice and
Let me
always a
join
justice.
again. That's how it will get.
नहीं, it's okay, Unnat भाई, doesn't matter. It's okay.
Ma'am, I think we should start. Himani?
Okay, sir. A very warm greeting and good morning to our esteemed panelists, faculty members, and participants who have joined us. Welcome to the 5th session of 3rd International Conference on Mediation, organized by Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance, Institute of Eminence, University of Delhi, in association with Mediation and Conciliation Project Committee, Supreme Court of India. The topic of 5th session is Role of Mediation in Commercial and IPR Dispute. To discuss various parameters of it, we have a stellar list of distinguished speakers, with each of them being an expert in their own domains. We humbly invite Honorable Justice Prathiba M. Singh, Judge, Delhi High Court, our esteemed chair, Professor Unnat Pandit, Controller General of Patents, Design and Trademark, Government of India, being the respected co-chair, our guest of honor, Professor Dr. V.K. Ahuja, Honorable Vice-Chancellor, National Law University, Judicial Academy, Assam, and Joint Director, Delhi School of Public Policy and Governance, Institute of Eminence, University of Delhi, and our admirable special guest, Shri Tejas Karia, partner Shardul, Amarchand, Mangaldas and company. We welcome you all. Without further ado, I would like to introduce our moderator for the session, Professor Dr. Vageshwari ma'am. Ma'am is an Indian academician, feminist, jurist, author, and activist who teaches at Faculty of Law, University of Delhi. Ma'am is the treasurer of All India Law Teachers Congress, as well as member of the Indian Society of International Law and the Indian Law Institute. Ma'am is the project director for the Indian Council of Social Science Research Project for the Ministry of Agriculture and Farmers Welfare. I request you, ma'am, to formally welcome the panelists for this session. Over to you, ma'am.
Thank you, Himani. A very good morning to all the respected dignitaries, guests, and participants, and welcome to session 5 on day 2 of the 3rd International Conference on Mediation, organized by Faculty of Law, Delhi University, and Delhi School of Public Policy and Governance in association with Mediation and Conciliation Project Committee, Supreme Court of India. This session will be dedicated to understanding the role of mediation in commercial and IPR disputes. Now, online living has led to the emergence of disputes in cyberspace in varied forms, such as domain disputes, copyright disputes, trademark infringements, patents, privacy infringements, cyber frauds, and so on. Commercial mediation, it is a flexible, voluntary, and a very confidential form of ADR resolution in which a neutral third party, that is the mediator, assists the parties to work towards a negotiated settlement of their dispute. Thus, the parties, they retain control of the decision, whether and not to settle and on what terms. So you see, this is so unlike a traditional justice mechanism in which the parties, they feel alienated. So the commercial courts, commercial division, commercial appellate division of the High Courts Act 2015 was enacted with the objective of achieving a speedy adjudication of commercial disputes. Moreover, the commercial courts pre-institution mediation and settlement rules 2018 were also framed in line with this act to resolve the matters relating to commercial disputes in an efficacious and expeditious manner. Further, in 2018, Chapter 3A was also introduced in this act, which introduced Section 12A that mandates pre-institution mediation in case of a commercial suit of specific value, which does not contain any application for an urgent interim relief. As dispute resolution to commercial mechanisms could be very expensive if we take up the formal legal route. So mediation provides an easy solution to the parties involved in such intellectual property disputes. WIPO as an organization has also been playing a very significant role in bringing mediation to the forefront whenever there is a dispute involving intellectual property. So ADR today, it includes a wide variety of dispute resolution mechanisms, including mediation, arbitration, negotiation. While arbitration has been around for quite some time in intellectual property disputes, now mediation is also gaining ground, wherein the mediator, he acts as a neutral intermediary, helps the parties reach a mutually satisfactory settlement of their dispute. So to shed more light on this emerging area, we have with us a panel of eminent and illustrious names in the field of intellectual property rights, such as Honorable Justice Prathiba Singh, Professor V.K. Ahuja, Professor Unnat Pandit, and Shri Tejas Karia. So without taking much of time, I would ask Himani to formally conduct the session.
Okay. Thank you so much, ma'am, for taking out time and joining us today. I would now like to invite a special guest, Shri Tejas Karia sir, to kindly share his expertise with us. Sir is a partner with the dispute resolution practice at Shardul Amarchand Mangaldas and also heads the firm's arbitration practice. Sir has advised on the drafting of amendments to a number of key acts, including the Indian Arbitration and Conciliation Act 1996 and the Commercial Courts Commercial Division and Commercial Appellate Division of High Courts Bill 2015. Sir has also been a part of a high part committee set up by the Government of India for arbitration in India. Over to you, sir. So please.
Thank you for the kind introduction. Good morning, everyone. This is always a pleasure to come back and speak to the event by Delhi University. Today's topic is quite pertinent, role of mediation in commercial and IPR dispute. As we all know, commercial disputes, we always go for arbitration as the first option for dispute resolution, and mediation has not been exploited the way it should have been. In last 1 decade, we have seen a lot of traction in promoting mediation for the commercial dispute. Mediation has always been there. It's just that mediation is not used for resolving the commercial disputes in many of the high volume or high value complex commercial dispute. And now with the mediation bill coming in, we are going to see a complete change in the mindset of people to use the mediation in commercial dispute. The reason why we should consider mediation is time is equivalent to money in always in a commercial dispute, because the more time it takes to resolve the dispute, we lose money in the longer term. Again, the continued commercial relationship is very important, because when we go for disputes, we have seen that parties end their commercial relationships, and that is not good for their long-term benefit. As Dr. Deswal also said, confidentiality is paramount for all the commercial disputes, because mediation provides that kind of confidentiality, because in arbitration, from experience we have seen, from start to finish, at least we go to court for, say, interim measures, appointment of an arbitrator, or challenging of the award. But in the mediation, we have seen that there is a complete confidentiality. There is no way anybody comes to know about the dispute or resolution of dispute. So the way confidentiality is maintained in mediation is very important for commercial disputes. We have the Commercial Courts Act, Section 12A has been introduced, and we have the rules also formulated in 2018. The only question is that whether the pre-institution mediation is mandatory or not. Various high courts have taken a different view on the mandatory requirement of pre-institution mediation for commercial disputes. And the matter is now pending before Supreme Court, and we hope that we get a clarity on that. In my view, so far as the mediation is concerned, it's always helpful to try, because in a lot of commercial contracts, we have seen that there is multi-tiered dispute resolution clauses. Then courts have enforced this multi-tiered dispute resolution clauses. Many times we start with good faith negotiations, then mediation, and then go to more formal dispute resolution mechanism like arbitration, which is more in adjudicatory nature. And that results in one party winning or losing. Whereas in mediation, there is always a win-win, because both parties come to negotiated settlement with the help of mediation. Various high courts, including Bombay and Delhi, have refused to appoint arbitrators when parties have agreed to mediation as a first resort in case any dispute arises. So that is very encouraging for all of us to know that courts are also promoting mediation. The government is trying to bring the mediation bill into act. It's before the Joint Parliamentary Committee at present, and it should see the enactment very soon, and hopefully during this year itself. So once the law comes into effect, we will have a proper mechanism which is recognized by the statute for mediation. The only one problem I have, and I appeared before the Parliamentary Committee on behalf of CII, we have a couple of comments on that, is the conciliation part is now being merged with the mediation without making a distinction between mediation and conciliation. That may also be an issue when we don't have a conciliation as a separate dispute resolution mechanism which is independent of mediation. The second is the portion of the Singapore Convention on Mediation, which was there in the previous version of the bill, has been deleted in the latest version of the bill, so it should be inserted. The reason I say so is that in commercial disputes, and especially IPR disputes, which is again under Section 2C of the Commercial Code, is included in the definition of the commercial disputes. We have a lot of cross-border dispute arising out of the IPR or the commercial disputes, where none of the parties want to submit to the jurisdiction of the other party, and they want a neutral mechanism to resolve their dispute. And that's where arbitration has gained prominence in terms of dispute resolution. If we talk about cross-border disputes, we have New York Convention for enforcement of foreign awards. And similarly, Singapore Convention will get that sanctity for the mediation, negotiated mediation settlement to be enforced across the jurisdiction wherever the signatories are there. And that would again help us to bring that a statutory recognition by way of the Mediation Act as and when it comes in. If we talk specifically about the IPR disputes, there are a lot of advantages of doing the IPR disputes through mediations. We have seen in practice trademark, patent, copyright and designs, all these aspects of IPR are getting resolved through mediation. Domain name dispute is again a big part of the dispute resolution where mediation can be of great help. We also see a number of disputes where this intellectual property rights are violated on social media intermediaries. And we see number of cases going to the courts. We can reduce the burden of the court by directing them to mediation, because intermediaries like Facebook and other YouTube, they don't play an active role in publishing this material. They have a neutral role to play. And when the matter goes to court, the real dispute is between the uploader and the IP right owner. And we have seen in number of cases the matter getting resolved after the grant of injunction. Either the uploader has to take it down or the intermediary has to take down that content, and the matter gets resolved through mediation without going into the trial. That way, the mediators can really help to draw a complete master plan to resolve the dispute with their expertise. And if we have expert as mediator, they can deepen the knowledge of the parties. They realize the rights and obligation of each of the parties in terms of the IPR disputes. And number of cases we have seen that you have resolved through mediation, even involving complex IPR disputes. The next point I wanted to discuss is institutionalization of mediation. We have seen mediation is mostly referred by the court to the court annex mediation centers. We don't have contracts, commercial contracts having mediation referred to the mediation institutions. Now, under the new act, we will have the mediation service providers, and those service providers will have facilities and the rules to provide the mediation service. They have the expert mediators. And what we have seen in actual arbitrations, when we have the hybrid clauses like MED-ARB-MED or ARB-MED-ARB clauses, in SIAC, we have SIMC, which is Singapore International Mediation Center. They have a protocol between SIAC and SIMC. And many times we start with the arbitration, go to mediation, and then come back to arbitration for unresolved disputes. And that has really helped. In one of the cases which we were doing, it was a shareholders dispute. The question was about selling of shares at a particular value. What we could arrive in the mediation is that, yes, we will pay, but how much will be decided by the arbitrator. So it reduced the entire arbitration to almost half, and the cost also went down significantly. So with the help of mediation, we can really reduce the cost of the entire dispute resolution mechanism. It saves time, and the enforceability increase manifold, because once you have a mediated settlement, it is enforceable without any question of being against public policy, or no procedural issues comes up which we face in the arbitration. It will really reduce the burden of the courts. And with the institution mediation, what we will have is that there would be proper rules for conducting the mediation, which will be time tested. And the mediators would be experienced in a particular type of dispute, which is getting mediated. So that would really help the parties to come to a negotiating table and resolve their dispute. That would go a long way. What we have seen is that mediation has been successful in family matrimonial disputes, and courts have really encouraged parties to settle their dispute. But with the commercial disputes and IPR disputes gaining prominence in across, and with the kind of infrastructure we have to resolve this dispute, we can do capacity building, proper training of the mediators in these particular sectors, and really ensure that the commercial and IPR disputes are resolved through mediation in a big way. With that, I will end my initial thoughts, and I look forward to hearing honorable judges and professors. If there are any questions, I'll be very happy to answer. Thank you.
Thank you so much, sir, for educating us about the subject and sharing with us such valuable points. I would now like to invite a guest of honor, Professor Dr. V.K. Ahuja, sir, to share his rich experience in the field. Sir, in the past 26 years of his academic pursuit as a faculty member and researcher, has established himself as an acknowledged scholar of intellectual property laws and international law. Sir has authored 4 books on intellectual property rights and international law. Sir has delivered several well-commended lectures at World Intellectual Property Organization, Delhi Judicial Academy, Bihar Judicial Academy, and Jharkhand Judicial Academy, Ranchi. Sir has served as Joint Director of Delhi School of Public Policy and Governance and Professor in charge of Law Center 2, University of Delhi. Sir has taken over as the Vice-Chancellor of National Law University and Judicial Academy, Assam in June 2021. Over to you, sir.
Thank you, Himani. Honorable Madam Justice Prathiba Singh, my friends, Professor Unnat Pandit, Mr. Tejas Karia, other honorable judges from various high courts, my colleague at Faculty of Law, Vageshwari, and dear participants, a very good morning. A lot of things have already been stated by Mr. Tejas Karia. Well, friends, as Mr. Tejas had rightly pointed out, that mediation is a time-tested mode to resolve all types of dispute, be it political or boundary dispute between two nations or states, family dispute, commercial dispute, or any other dispute. We can find the reference of mediation in our epics Ramayana and Mahabharata also. In the justice dispensation system, mediation got a late entry in a formalized manner. Although it was already there, as Mr. Karia had pointed out, but it got a late entry in the formalized manner. In 1997, an attempt was made by Parliament by proposing insertion of Section 89 in the CPC, and that was aimed to settle dispute outside the court. So Section 89 was finally inserted in CPC in the year 99, and it became effective from 1st of July 2002. Though it was a good beginning, yet it could not bring the desired results because the backlog of cases, kept on increasing. In case of commercial disputes, the real breakthrough was achieved in 2018, as had been pointed out, when the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015 was amended to bring in Section 12A, which provided for the mandatory pre-institution mediation and settlement in commercial disputes. The good thing about these rules, this amendment, was that the process of the mediation is to be completed within 3 months' time, which could be extended by another 2 months on the request of parties. In case there is a settlement between the parties, the same will have the status and effect of an arbitral award. So that way, if we just look at 2018 amendment, it somewhere gives the finality to mediation. And that is extremely important in the commercial cases, particularly the IPR cases. Well, friends, the commercial courts pre-institution mediation and settlement rules 2018 are extremely important as far as mediation in commercial disputes, including IPR disputes, are concerned. These rules are quite comprehensive to deal with various aspects of mediation in IP disputes. There may be IP disputes regarding ownership, licensing, franchises, multimedia, know-how, infringement, joint ventures, merger and acquisition where IP issues are involved, fixation of royalty rates, research and development contracts, etc. The mediation can be successfully tried on all these cases and bring the desired results. The Commercial Courts Act of 2015 defines commercial disputes to include a dispute arising out of IPR relating to trademarks, registered and unregistered both, copyright, patent, design, domain names, geographical indications, semiconductor integrated circuits. It does not include plant varieties, biodiversity, traditional knowledge, and confidential information, including trade secrets. So that remains outside the definition of the commercial dispute as provided under the Commercial Courts Act of 2015. It, however, covers the franchising agreements, distribution and licensing agreement, management and consultancy agreements, and joint venture agreements. So wide coverage has been given, so far as the definition is concerned, but certain things are outside the purview of these rules. But then if there is a dispute, nobody stops you, for going to mediation, even for all those things which have been left out. The mediation rules do not apply where application for interim injunction is to be filed. Now, this is something very interesting, because if you just look at the many trademark cases, for example, there are many examples you will find. In most of the cases, the matter does not come for trial on merits. So once the interim injunction is issued, the infringer, the so-called infringer, stops, using that. And ultimately, the matter somewhere is, settled there only. It comes to an end. Mediation that way is not of much use in these cases where interim injunction is to be filed. One important thing about mediation rules of 2018 is that it lays down some ethics to be followed by the mediators. Now, this is extremely important. And as I told you that mediation is being introduced in a formalized manner. It has been introduced in a formalized manner recently only. Now, if you have to develop a system, you need to ensure about its integrity, its credibility. Mr. Tejas had rightly pointed out that, well, the mediators are required to be trained. And this is something which is extremely important, because once this credibility is not established, or if suppose there are cases where the parties doubt the integrity of the mediators, then obviously it can bring a bad name to this particular institution of mediation. So something is required to be done here. And good that 2018 rules talk about the rule. This is section 12 of the rules, which talks about ethics for mediators. Mediation, of course, is very important in all IP disputes for the reason that it is less time consuming, in addition to being less expensive. And of course, it can involve all those cases which are the cross-boundary cases also, where there are parties from two different states. IP disputes are normally high-valued cases. And as Mr. Karia had pointed out, that the time is extremely important, as most of these IPRs subsist only for a particular period of time, except for trademarks and geographical indications. Patent is there for 20 years from the date of application. Copyright also has a limited life, but of course, that is much longer in comparison to others, and that is author's life plus 60 years. Or a design, again, is for 15 years at the most, 10 plus 5, and semiconductor layout designs, they are just for 10 years. So if the matter goes in litigation, and if the litigation is prolonged, then obviously they are going to, lose a lot of revenue. And that is why the mediation becomes extremely important. And the IPR owners, they want their disputes to be resolved at the earliest. Another important reason why mediation is important in IP cases that has again been pointed out by Mr. Karia is, and that is the confidentiality. So obviously, IPR is something, where a lot of confidential information is there, and no party would like that confidentiality to come out in public, because it is going to cause irreversible damage to their business if it happens. So again, a mediation becomes a preferred choice. As Vageshwari has also pointed out in the beginning, there are WIPO mediation rules also, which were adopted in 2016. And these rules consist of 26 articles covering various aspects of mediation. And the mediators appointed under these rules are competent to deal with different classes of IP disputes. The WIPO Center for Mediation is being considered as a neutral, independent, and non-profit dispute resolution provider. And it is considered as a leading institution throughout the world. entities of more than 60 countries. Now, that again is something very good, that they have reposed faith in WIPO Mediation Center, and they have availed the mediation services of the WIPO. I was just looking at some data, though it is not an updated one. So it is like 70% of the cases which were referred to WIPO Mediation Center, they were settled through mediation. Whereas I think some 40% were, decided. It resulted into arbitral award when it was referred to arbitration in the WIPO. So that way, the rate of mediation was better than arbitration. And if you look at the Philippines, also one country where mediation is compulsory for IPR cases, and it has also mediation has also proved to be very effective there in disposing of such cases expeditiously. And there are like 45% cases in the Philippines which resulted into settlement agreements. If we look at the USPTO, so there are two boards. One is Trademark Trial and Appellate Board, TTAB, and another one is Patent Trial and Appeal Board, that is PTAB. These are the two wings of USPTO, and they also encourage parties to settle their disputes through ADR, including mediation, and they consider WIPO Center as one of the listed dispute resolution service provider. Well, friends, to sum up, what we can say is that mediation may prove a boon for the IP disputes, provided its credibility and integrity is established. It has been seen that in many of these IP cases, settlement happens and ultimately the so-called infringer takes a license to use the IP. Now, that is something which is extremely important about mediation, because it maintains the cordial relations between the two parties. When this cordial relation is maintained, then obviously it results into a win-win situation. The so-called infringer takes a license, and the commercial relations, they continue, and both of them benefit by this settlement deed. So ultimately, mediation, if we just look at, if we look at all the characteristics and the benefits of the mediation, I think it is the need of the hour. Of course, we have already adopted that. Mediation bill will soon be, enacted. Let us hope so that it is done in this year only. And let us hope that the credibility is also established for the institution of mediation in the country. With these words, I thank you all.
Thank you so much, sir, for taking us through the very intricate details on mediation and beautifully capturing the entire essence of the discussion. I would now like to invite the co-chair for a session, Professor Unnat Pandit, Controller General of Patents, Design and Trademark, Government of India. Sir has served as officer on special duty to the then Commerce and Industry Minister, Srimati Nirmala Sitharaman Ma'am, at Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India. Sir was the former member of IPR think tank constituted by Department of Industrial Policy and Promotion, Government of India, to draft National IPR Policy of India. The virtual floor is yours, sir. Please.
Thank you. Can you hear me?
Yes, sir. We can hear you.
Thank you, Himani. Honorable Justice Prathiba Singh ji, Professor V.K. Ahuja, Tejas Karia ji, and the respectable judges and the students and faculty. I would like to specially mention here that this is a much historical event which is being conducted by the Faculty of Law, University of Delhi. They are celebrating, University of Delhi is celebrating a century year of academic excellence. And I must mention that in Faculty of Law, we have seen various alumni, distinguished alumni who have par excellence, they have already established, and they have set a landmark in the history. There are so many alumni. We can, our existing Law Minister Kiran Rijuji is one of them. Honorable Justice, various judges from the Supreme Court, High Court, and distinguished politicians also. One of them is Shri Arun Jaitley ji, who has led the nation on various fronts, and his contribution is immensely remembered by all of us. Beside this, one more auspicious day today, Ram Navami, and we are discussing on the mediation, role of mediation in commercial and IP dispute. This day is also remembering, we should remember that we are getting so much of the lessons from Ramayana. And of course, I have taken a charge as a controller, so I won't be discussing much on my new role because I am fairly new. I need to understand about entire system. So it would be unfair if I make any comment without knowing and without getting much into the system. So being an academician, I would like to share some of my thought as a management professor in JNU. And for mediation, of course, the two aspects we need to remember. One is the aspect as an individual who is voluntarily contributing for the mediation. And there are three essential qualities of those people. And this is more focused to the students who are watching this in a virtual mode. Three sir is essential. Samanvay, Samvad, and Sahbhagita. You need to develop those skills towards encouraging the dispute parties to come forward, discuss, cooperate each other, and then bring the synergy in this. And if you have acquired all those skills, then you can become an efficient mediator. There are various modes through which the mediation activities is being conducted. Tejas, Karia ji and Professor Ahuja has already well described all those activities happening nationally, internationally, and but looking to today's day, Ram Navami, what lessons Ramayana is teaching to all of us in mediation? I would like to throw some light here. There are 5 lessons which we learn from Ramayana on mediation. Nurturing business relations for strategic alliances. Mediation offers this opportunity. Rather than competing with each other, we need to bring the parties together to bring the synergy in their alliances. Ram and Sugriv, both together, have made this alliance. Ram has tried to mediate, utilizing his efficient skills towards bringing both the Sugriv and Vali together. So these are the lessons which Ramayana teaches us. Great leader creates more leader. This is the lesson for the patent agent, trademark agents. If any such mediation opportunity arises in the IP dispute, you need to proactively support this. You need to initiate various such pros and cons, addressing pros and cons which are there. But even though your efficient qualities in addressing them can really help this mediation activity catalyzing the impact. And your role as a leader in creating such legacy for the mediation is important. Currently, the patent agents and trademark agents can actively play this role. And this is one more lesson which Ramayana teaches us. Third lesson is the importance of a communication. And that's why your skill, Samanvay, Samvad, and Sahbhagita, will help you in creating the bridge between the disputed party. And that's the more essential lesson which even Ramayana is teaching. Hanuman went to the Lanka and then established the way of a communication. And when this was not happening, he has tried his level best to at least let's have the dialogue. Vibhishan, again, this let's have the dialogue. This is the important lesson where this kind of a legacy is there in Indian culture. The fourth one is a planning the successor. So if you have established this, teach your juniors how they can play the lesson and how they can also play active role in this activity so that evergreening happens. We can reduce the load of courts which is there, and pending cases can be addressed through such an effective mechanism which is there. The fifth lesson which we learn is efficient management lies in inspirational and utilizing the best resources which is available. We have such resources available, best resources are yet to be utilized to the fullest extent. In our national IPR policy also, we have mentioned in our enforcement and adjudication clause, wherein 6.10 clause, which mentions about facilitate the efficient and adjudication of IP and dispute through different measures, which includes the one of the measure is a mediation. And many such recommendations are already implemented. And I'm happy that even after Honorable Ma'am Justice Prathiba Singh ji joined the Delhi High Court, there is a commercial court and the IP bench which is created. So I must congratulate ma'am for this, leading this, and I'm much thrilled that this is something which is going to be set a landmark in country, and we need many such dedicated IP bench where all such dispute can also be resolved. And equally, we need the IP mediation centers where we can resolve all such disputes. Country is progressing well. Country has a long legacy of utilizing the knowledge and intellect. Such disputes are creating intermediary hurdles in the economic growth. Our best possible opportunity should be to resolve them timely and efficiently. And I am sure this is going to be resolved in future. Without taking much time, I would like to thank the organizer for giving me this opportunity and would be eager to hear Honorable Justice Prathiba Singh ji. Thank you.
Thank you so much, sir, for telling us so comprehensively about the mediation. I would now like to invite the chair for a session, Honorable Justice Prathiba M. Singh, Judge, Delhi High Court, to share her extensive knowledge and enrich a discussion on this topic. Your ladyship has provided expert advice to parliamentary committees on proposed amendment to intellectual property laws in India, including the Patents Act and Copyright Amendment Act 2012. Your ladyship was also a member of panel that was constituted to draft India's national intellectual right policy in 2014. Your ladyship was appointed as a permanent judge in the Delhi High Court on 15th May 2017. The virtual floor is your ladyship.
Thank you, Himani. Very good morning. Namaste. It's been wonderful. I've been sitting through this entire session, right from Mr. Karia to Professor Ahuja to Professor Unnat Pandit. Thank you, Professor Ashutosh, for inviting me on this panel. In fact, whenever Delhi University invites for seminars, I've realized at least on 2 occasions I had to say no, but this time I could make the time, and I'm very happy to be on this panel. Though I'm not a product of Delhi University, because of whom I'm married to, I do owe a kind of responsibility to Delhi University, both because of my husband and because of my daughter, who have both studied at Delhi University. Professor Ahuja, I mean, you know that my daughter studied under you, and it is wonderful to be back. And I always enjoy going to Delhi University, and I really wish, that Delhi University really grows in its centennial year and grows from, strength to strength. It has produced large number of qualified alumni in the past, and it should continue to produce great, academicians, lawyers, judges who will make a contribution to this nation. And Professor Unnat Pandit, heartiest congratulations to you for taking over as the Controller General of Trademarks, Patents and Designs. I can't think of a better person who could have been there with your immense experience on, IP and being part of the think tank with all of us. We've worked so much on the IPR policy. You have a good vision, a soft-spoken visionary is what I would say. So I'm quite sure that the IPR administration is in safe hands with you, and you will take all the measures required to strengthen it, to make it more transparent, and to make sure that the IP administration, again, which has already gained a lot of strength, will become much better as we go forward. With that introductory comment, I also wish to pay my regards to all the honorable judges. I cannot see most of them. I'm not sure if they're online. So I'm sorry if I didn't refer to you initially. Today we are in the topic of IPR as a, mediation in the context of commercial disputes and IPR. And I must say that the pandemic, and even before that, mediation has been one of the best modes of resolving commercial disputes. And my personal experience tells me that it's easier to resolve commercial disputes and IPR disputes than family disputes and matrimonial disputes. And because of the rosters that I've held, I can see that there are so many problems when we deal with family and matrimonial cases. There are personal egos of parties which are involved. So those mediation proceedings prove to be more challenging a lot of times. However, but in commercial and in IPR disputes, the trends are excellent, and in IPR the trend is outstanding. I will just tell you the statistics, and you will completely be surprised at how mediation is doing such a big job. Before I do that, I want to take a few minutes to just mention about mediation in Delhi courts and Delhi High Court in general. I'm not sure how many of you are aware. One of the earliest mediation centers set up in our country itself is the Tejas Mediation Center. It is a very, very successful mediation center. We have about 6 to 7 mediation centers across district courts in Delhi. And you will be surprised, since 2005, in Tejas, 1.25 lakh cases have been referred to mediation. That is a huge number. If you see the, growth of mediation, for example, in Karkaduma, we have about 70,000 cases already referred since establishment. Rohini courts, Dwarka courts, Patiala House courts, Saket courts, total mediation cases since the establishment of all these centers is more than 3 to 3.5 to 4 lakhs, which is a huge number. You can imagine how much infrastructure is needed to deal with these kind of cases. How many mediators are required? How many cases are being settled? It is now, mediation is quite well entrenched in the court system. Now, if you come to, the trends in the mediation cases, in 2017, 33% of the cases which were referred were settled. And this trend has been around 30% between 2017 to 2021. This is in civil cases. This is overall. If you come to civil cases, the trend is between 20 to 25 only. But in commercial disputes, the trend is around 30%. And in IPR cases, I must tell you, in 2017, 100% of IPR cases which were sent was settled. In 2018, it is 75%, 2019, 85%, 2020, 97%, 2021, of course, the pandemic was a problem. It's around 68%. The overall trend is more than 85% settled for IPR cases, which I think is a phenomenal settlement rate, because it is not possible to have such a high level of settlement if mediation is not successful in IPR. And this trend actually, the Gujarat High Court had organized a seminar this weekend, and they wanted to publish a brochure. And I collected the statistics for that particular seminar, which may have been published. I'm yet to receive the copy. But when this statistics came to me, it was a shock to me. It was a pleasant surprise to me to just see that the high level of IPR cases which are settled in mediation. And it just proves that in IPR, people are happy so long as their rights are safeguarded. Defendants are happy if they can compromise and move on in their commercial matters. And the recent trends, I must tell you, in the last 1 month, I have been presiding in the IP division. We have given a big role in IP division rules as well, and in patent cases for mediation. And if you read both those rules, you will find a specific clause dealing with mediation in both of them. That is, of course, on paper. But let me tell you my experience in the last 1 month in the Delhi High Court presiding over the mediation center, presiding over the IP division. My own assessment is in trademark and copyright matters, the settlement is extremely comfortable and easy, whether it is under the mediation center or through the court proceedings. Lawyers are very, very reasonable. Litigants are very reasonable, both plaintiffs and defendants. And every day, with some modification in a trademark case of the mark, sometimes if a logo is involved, they are willing to modify. They are willing to restrict the products for which they will use it. Even the cases which are coming from appeals from the trademark office, they are also getting resolved very easily. And it is an amazing trend that I'm seeing, that in IPR cases, the trademark and copyright matters, it is very easy to mediate. And in most of the cases, the defendants, this is the other new trend that I'm seeing, they are willing to pay some costs, they are willing to pay court fee. Sometimes they're even willing to pay actual costs. I have awarded 10 lakhs, 12 lakhs, 15 lakhs, 5 lakhs as costs in the last 1 month. And they do it in a very comfortable and a congenial and an amicable manner. It is not like, they're being pressured or in any way, because they do realize that they will be spending so much money on the litigation if they don't pay. And that doesn't work for them, because they're happy to move on with their business. They don't want the uncertainty of litigation hanging on their head. So trademark and copyright, it's well established. Now let me tell you the surprising trend in patent cases. In the last 1 week itself, there have been at least 5 or 6 patent cases that have been mediated in the court itself. So in patent cases, broadly, there are 2 categories which we are seeing. One, of course, is the pharmaceutical patent cases, where in the pharmaceutical cases, the issue, if it is a main new molecule patent which is involved, and there is a injunction already granted or otherwise, and the patent is going to come to an end in the next 3 years, 4 years, 2 years, whatever it is. If it's a new molecule patent, most of the defendants are willing to undertake that they will not make the product. And the only condition which they ask for is, you permit us research and development during this period so that as soon as the patent expires, we are able to launch our product. So that is the 107A bowler exception protection that they seek. And most of the defendants come and say, okay, we are willing to give an undertaking, but we don't want to be stopped from research and development. We want to make our own new formulations. This is in terms of molecular patents. The contested matters in pharmaceuticals are when there are multiple patents which are there by the plaintiff. There's one molecule patent, and then there's a formulation, there is a salt patent, there's a polymorph patent. In those cases, the validity is challenged, and those are the contested matters in patents, which are required to be heard and which are required to be adjudicated. The other third thing is, as Professor Ahuja also mentioned, licensing of other technology patents, whether they are standard essential or non-standard essential patents. The licensing of these patents is the next thing that is happening in the courts. Most of the defendants do challenge the patents. However, when the court starts hearing the matter and they realize that, most of the times these are ex-licensees as well, who already had an agreement, their agreement has lapsed, the negotiations are going on. So while the litigation is going on in the court, they are conducting parallel mediation. So there is a parallel mediation going on. So by the trend in the litigation, the mediation is going on, the double pressure works, and they do settle with licensing in a large number of cases. And the next thing that is happening in the High Court in terms of mediation is the pre-litigation mediation, which is a very big trend again. In pre-litigation, I am told in the Delhi Samadhan Center, in the Delhi High Court, large number of pre-litigation cases are coming, and the settlement percentage in those cases is also quite high. I am aware personally of a series of patent cases which were settled, 8 or 9 patent litigations, which were settled only by pre-litigation mediation. Only a notice was issued, the defendant came to the mediation center, they talked, they mediated, and it was settled. And this, I think, is a very good trend which we are seeing. The one thing that I would like to highlight about our Delhi High Court Mediation Center, which is known as Samadhan, is that there are good training which is being imparted to mediators, basic, practical, and advanced level of training. They're paid a reasonable amount, and a large number of senior advocates and well-established advocates work as mediators in our center. Though the money paid is not very high, they are willing to contribute to the center, they're willing to contribute to mediation, and they are appointed every day by us as mediators. The second important thing is, as Mr. Karia mentioned about confidentiality in mediation, the Delhi High Court has a set protocol and maintains very good confidentiality. In the pandemic, I want to tell you that in commercial matters, the 2 years, 20 and 2021, the mediation statistics, earlier it was 30%, in the pandemic it is 45%. So it just shows that in pandemic, most of the cases, at least almost half the cases which are referred to mediation, people are willing to settle because they feel that it's better to, have some kind of settlement rather than insist on high interest, or monetary cases are also getting settled easily. So between 30 to 45% difference, I think it's a huge difference, pre-pandemic and in pandemic. And so the trend is very good for mediation. Coming to Professor Unnat Pandit and his new role, I have a couple of things I want to mention on trademark and patent cases. One concerning area is the fact that there are more than 2 lakh oppositions which are pending in the trademark registry, where we are facing a large amount of bottleneck in the adjudication. There's a recent order that has been passed. The trademark office is to put up a proposal before us. In between, before I was elevated, I remember we had tied up with the Patiala House Mediation Center for settlement of opposition proceedings through mediators. I think this is going to be a huge challenge, one of the biggest challenges that Professor Unnat is going to face as the Controller General of Trademarks. I'm sure he will put his head together with his team and put up a good proposal on that. Please include mediation in that as a part of the process of settlement. And patent oppositions, I think that the time has come for IPR that with the IP office itself, there needs to be a trained center of mediators which will work, because I think a large number of IP disputes can be settled in the patent office, trademark office, if they have an established good center running there. So that could be one way of looking at it as a way to go forward. And please tie up with some established mediation center so that it can provide you a high level of mediators, proper protocols and proper systems can be put in place. And it's time to use mediation even in the IPR registration and opposition proceedings is what I feel. And these are my comments for IPR mediation. We've all met on a very auspicious day, and I wish everybody a good season's greetings, and wishing you all good health as we've all moved out of the third wave, and hopefully we are out of this pandemic, and wishing everyone and their families all the best. Thank you so much.
Thank you so much, Your Ladyship. It was an honor to have you with us today. It was a very comprehensive and solution-driven session. Now, I would like to request Professor Dr. Vageshwari ma'am to share the concluding remarks and propose the vote of thanks. Ma'am, over to you.
Well, that was such an amazingly brainstorming session. The organizers, especially Dr. Ashutosh, have done a commendable job by managing to arrange the best experts in the area to speak on this emerging area of jurisprudence here today. It is my privilege to propose a vote of thanks. And let me begin by first of all conveying a big thank you to all of our guest speakers for obliging us by taking time out for us on a Sunday. With your packed schedules, Sunday is the only day of the week when you have some time to unwind, but your commitment towards this field is evident by your presence here today, and we have all been enriched by your discourses. So thank you, Shri Tejas Karia ji, for so simplistically explaining the subtle nuances of mediation in commercial areas. Professor V.K. Ahuja traced the evolution of the modern day mediation, starting from the ancient practices of settlement mentioned in Ramayana and Mahabharata, the WIPO rules, and the recent introduction of mediation as a formal mechanism. Sir, you so explicitly clarified the reasons why mediation is important and it needs to be promoted in intellectual property disputes as a win-win situation for all the parties. Thank you so much. Thank you, Professor Unnat Pandit, for co-chairing the session and explaining the concept of mediation so lucidly, again with examples of Hanuman and Sugriv from Ramayana. So yes, this is not an alien concept to us. It comes naturally to us and we should promote and explore it. Honorable Justice Ladyship Prathiba Singh, thanks a lot for chairing the session and enlightening us on so many hitherto unknown or rather not celebrated facts relating to mediation, such as the efficient working of our first ever mediation center in Peace Hazari, the positive response towards mediation during pandemic, and many more. Thank you, ma'am. It's a delight to hear you always. Mediation has the potential of transforming the nation's judicial process. However, there are some bottlenecks such as lack of sufficient number of trained mediators, infrastructural handicaps, etc. The government's mediation bill has been referred to the Parliamentary Standing Committee and is reportedly taking a very good shape. So we do have a lot to look forward to. So again, thank you all and enjoy your Sunday now, whatever is left of it. Anyway, thank you again.
Thank you, ma'am. The insights shared by the panelists have truly been thought-provoking and informative. I again thank all of you for making this session a huge success. I would request everyone to kindly fill up the feedback form. Also, the same link will be active for a next session. With this, the session comes to an end. I wish everyone a great Sunday. Thank you so much.